conferences in chambers.
In chambers conference, I want to try to anticipate problems that I want to have with witness schedules, with witnesses that are going to have to be put on out of order, with documents that are not going to be available at the appropriate time, that will be there, so that we can discuss in chambers how we're going to handle it to avoid a problem once we get out in the courtroom. We want to disclose who the proposed witnesses are so that we don't prepare a case, go halfway through discussing it with the other side, only to find that this happens to be the judge's brother-in-law that's our expert witness. Evidentiary matters, such as lost documents or evidence which will be subject to motions to prevent introduction as evidence, should be discussed at that stage. A motion to exclude witnesses, in all fairness, should be done in chambers or to advise the parties if they're going to make such a motion. Generally, they're granted, but it is categorically unfair to wait until people have come to court in anticipation of giving their testimony, only to make the motion to exclude them, and probably they could be waiting out in the hall for 2 or 3 hours without even an appropriate place to sit. Finally, the judge's ground rules. They're not as important in that short cause matter, but how many of you have gotten to that situation where you first ask to have the clerk mark your documents for identification, only to have the judge say, "Why are you going through that? Just offer it up and let's get on with it." Find out in advance. You don't want to be embarrassed in front of your client. You don't want to be embarrassed in front of the other counsel. But now, the in-chambers conference in a family law matter I regard as an entirely different event. Because you have to remember that you've gone into chambers with that pre-trial statement, perhaps that brief on the last couple of points that the law might be in a state of flux or unknown to the court. But you're going in already presenting to the court the evidence that the judge is going to see. But in that in-conference chamber, usually the judge is going to say, "Let me know what this is all about. What's happening? What is it you want?" And you begin the process at that last minute of trying to find that particular way that the facts and the law and your client's interest can mesh together with the other side. The judge will want to try to have you pinpoint what the issues are. There you can briefly give the judge what it is that you hope to have him do, why it is that you hope to have it happen, and if he doesn't, what's going to happen. I think it's absolutely vital for your client that it not be a secret that you're only going to reveal at the time of trial as to what it is you really want. That in-chambers conference is the place to discuss it, because it really is not very unusual to have surprises come out at the trial. Everybody knows what's going to be happening. Both sides know what the facts are going to be. They should have a pretty good idea what the parties want. Use the judge in chambers to start trying to limit those issues and see what it is that you can get on that client's priority list. When you finally get out in the courtroom, all the judge is really hearing is verification and support for what's in your pre-trial statement and what you told them in chambers. That in-chambers conference is vital. And once you have the judge understanding your side of the case and what your client wants, you've gone a long way towards delivering the facts that your client needs and presented. You've got the judge listening to support the reasons why you want the results that you're seeking.
The judge doesn't, however, want to hear all of the evidence twice. In fact, in many cases, he'd just as soon not hear it even once. So don't use the chambers conference as a way of trying your case preliminary to actually putting on the witnesses, and you ought not to use that as an opportunity to argue the case. So there are a number of things, as Lauren has said, that can be done very effectively and can help to reduce the trial time. Not only should you learn the judge's practice with respect to marking exhibits, but there's no reason you shouldn't ask permission to have the exhibits pre-marked. There are a few things more wasteful of time than the time many court clerks take in marking the exhibits. So if you have a number of exhibits that you're going to offer, ask permission to have them pre-marked for identification at the very least. But in many cases, you'll be able to get a stipulation from opposing counsel that they may be marked in evidence before you ever get to trial. There are a number of other matters that can be taken up with the judge in chambers. Questions of when he usually takes a recess, how long the mean recess is, things that may be important to you in scheduling your witnesses and asking them to come into court. Richard said earlier that just before trial you ought to look at the clerk's file to be sure it's complete. I don't want to mention any names, but there is one county clerk's office I know of that can be counted on to misplace files almost as frequently and as completely as the post office department misplaces mail. And I have just within the last 2 or 3 weeks tried cases with no file at all. And the result has been that to the extent that I've learned anything about the case and its status, I've learned it from the copies of pleadings that have been supplied by counsel. So for one thing, I urge you to bring copies of all pleadings, bring your complete file to court in case it's needed. And secondly, if you haven't checked the file earlier, do it while you're going from master calendar to trial department to be sure everything is there. Now, our next matter is the opening statement, and in short causes, I would like to hope that you'd be prepared to waive an opening statement. At the very most, the opening statement ought to reflect the length of the trial, and so it should be quite brief itself. If you submitted a trial brief to the judge in chambers before he takes the bench, and even more particularly if you've had a chambers conference before trial, you can usually, with no fear of loss at all, and in fact with the hope of incurring a good bit of goodwill from the judge, waive an opening statement. But as I say, if you must insist on it, let it reflect the trial itself and be brief. Be careful to remember that the purpose of the opening statement is not to argue your case, but to simply advise the trier of fact of what you hope to prove and why you think it's important, so that a judge or jury in a jury case will be able to follow more easily the evidence as you present it. Richard, will you tell us something about the development of the evidence in the course of trial?
Well, this is, of course, what a trial is all about, is the physical presentation of your evidence to the trier of the fact, in this case, a judge. Several of the things that we've mentioned all culminate now in putting on that witness in the order in which you choose to put on your witnesses, and in what steps you take even now to shorten and simplify the trial. The judge has already commented on pre-marking exhibits. But what he didn't say is it doesn't hurt you to have 4 sets of those exhibits. That way they can be pre-marked for the judge, but the witness can have a set, opposing counsel can have a set, and you have one, and you don't lose however many trial minutes you've got passing that document around while everybody looks at it and reads it. Remember, we're talking 5-hour time limit, and the time you can save by having sufficient copies of your documentary exhibits can be crucial if you're going to have a lot of witnesses. When we talk about putting on a trial, we're not talking about presenting evidence, everything we know about the other guy and what a bad guy he is and why my client should win this thing. We're really talking about a very highly structured system which has evolved over several hundred years, which has distinct stages. And the use of those stages helps to control the flow of information to the trier of fact. The more orderly you can make your presentation of evidence, the easier it is you make it for the trier of fact to follow what it is you are getting at. Before you sit down to ask your first witness any questions, make sure that you have reread not only all your opposing counsel's pleadings, but your own pleadings. People get into a trial and they forget what it is that they raised in their pleadings. There's a question that you could ask yourself very simply. A sees B, who wins? Seemingly it has no answer. But of course B always wins, because A has to go forward and put on evidence of each and every element of his cause of action. And if he fails to put on that evidence, he hasn't met his burden, and he loses. If you remember that, and remember that there are 4 phases of the trial: the plaintiff's case in chief, the defense case in chief, the plaintiff's rebuttal, and the defense rebuttal, you can more accurately control the pace and flow of information. You will be sure by having a physical written or a mental checklist of ticking off every element that you need to prove to establish your cause of action. You'll get down to